Good afternoon, and thank you for joining us for the latest in the series of Claritas tax webinars. I'm Sarah Scala, Associate Partner here at Claritas, and I lead the Tax Dispute Resolution Service offering. I'm joined today by Michael Balmer, Partner in the Corporate Crime Team at Weightmans, and we're going to be speaking to you about HMRC raids. Before we begin, some minor housekeeping points. You're all muted to minimise disruption to the webinar, but please do feel free to input questions into the question and answer portal as we go along, and we'll be sure to check those periodically and deal with them at regular intervals through the presentation. There'll also be a question and answer session at the end. Just going to begin with some introductions. So, as I said, I'm Sarah. I lead the Tax Dispute Resolution Service offering. I deal with any form of tax dispute, usually involving HMRC, and that's both in relation to civil and criminal tax matters. And I've been in this line of work for the past 10 years, resolving tax disputes day in, day out. Michael, over to you.
Thank you, Sarah. Good afternoon, everybody, and thank you for the opportunity to speak to you at this webinar. As you've heard, my name is Michael Balmer. I am a partner in Weightmans. I head up the firm's corporate crime / business defence teams. I specialise in advising and representing individuals, businesses under investigation for financial criminal offences, more likely than not prosecuted or investigated by, but not exclusive to, Her Majesty's Revenue and Customs, but also including the Serious Fraud Office, Crown Prosecution Service, National Crime Agency, and others. So my background and expertise is in defending, assisting and representing individuals either prosecuted or under investigation by prosecuting authorities. And that can include events such as what we're going to speak about now, dawn raids, attendance at interviews under caution, responding to requests, formal requests under statute for delivering up business documents and things like that, right through to court proceedings, be they in the Magistrates Court, Crown Court, or appellate courts thereafter.
Thanks, Michael. So I'll just briefly explain what we're going to cover in the next 45 minutes or so. We're going to explain what you can do right now to best prepare for the unlikely but very serious eventuality of a HMRC raid. What to do if a raid occurs, the action that's required by a senior member of staff during the raid, the handling of the documents while the raid is in progress, what to do at the end of the raid, and what to do immediately after the raid. So let's consider what you could do now. The first thing I would suggest is to ask yourself if you as a business owner would know what to do if HMRC were to arrive unannounced, for example, tomorrow morning with a warrant stating that they were able to search the business premises. Or would your team know what to do? Because, of course, you can't rely on the fact that the person that opens the door to HMRC is the most equipped to handle that type of situation. Equally, if you're a professional advisor, you would ask a similar question. Would you and your team know what to do if a client rang and said HMRC had just arrived and you were expected as the trusted advisor to explain what action to take? So once you've considered that, we suggest that the best way to educate your team on how to handle the situation is to consider implementing a raids policy. So you would have a document that sets out exactly what to do. Your team would be aware of its existence, ideally and essentially they've read it in advance of the eventuality, and they know where it's saved, so that should a raid occur, they can pull it up quickly and follow the steps that are contained. This raids policy would include contact details for specialist solicitors, and when the raids policy is put in place, it's very important to save those contact details to mobile phones at that point, so they're readily available in the eventuality of a raid. We'd recommend backing servers up regularly, so that in the event of a raid, if HMRC sees electronic devices, you will still have access to electronic files and documents, which are crucial in continuing with the business while the investigation is underway. And finally, have plans in place to minimise disruption to the business and the effects of the raid. Now, it could differ from business to business depending on the business model, but it is something that we could speak to you specifically about after the webinar in a follow-up call. So I'm now going to hand over to Michael, who is going to address what I'm sure you're all wanting to know, which is what to do if a dawn raid occurs. Michael.
Thank you, Sarah. So these first couple of slides are going to deal with what occurs at the inception or the start of a dawn raid. It's likely that by definition officers will attend unannounced at a business premises with a warrant requiring seizure of a whole host of documents and computer equipment. So it's important that any business affected immediately calls specialist solicitors and where appropriate ask the HMRC investigating officers to speak with them. Even if the solicitors cannot attend straight away or indeed at all, they will be able to speak to the investigating officers over the phone and thereafter advise you on what to do. They should be able to speak with the lead officer also to clarify the terms and scope of the raid and if possible agree parameters so that Revenue and Customs don't have free rein, if you pardon the expression, to go through what may be irrelevant documents. It's worth noting that by definition, raids occur, as I've said, without warning, and therefore it's possible that solicitors may not be able to attend premises in a reasonable amount of time. HMRC are unlikely to pause indefinitely while solicitors to attend. They may agree to pause a reasonable time if solicitors can be there in sort of within 20 or 30 minutes, but even that may not be possible. So it's important that businesses and your clients have a procedure in place, and not only that it's in place, but that it's reviewed and refreshed to ensure anyone with responsibility is aware of the procedures in place. It's important that receptionists or indeed those people who are frontline staff are aware of the policy, because it's likely that they will be the first contact with Revenue and Customs officers. And it's important that they are trained and aware of the following: alerting a senior member of the internal response team, of the company's internal response team, to request a copy of the inspection team's authorization documents, including a court warrant and identification cards. That copies are taken of IDs and contact details are taken, as this will be important to follow up, as investigations may take many months to conclude. A dawn raid really takes place at the start of an investigation, but they can take many months, if not years, right through to their conclusion. Also, for frontline staff to prepare a list of members and names of the inspection team, and arrange name badges clearly identifying the inspectors as visitors to the premises. Sarah, could we have the next slide, please? Yeah, so it's important to ask officers to show you the warrant or authorization and to make a copy, even if that's just with your phone. Take a quick picture of it and send it through to the solicitors. Most importantly, request a copy of the warrant information. This will set out the focus of the investigation and what provision the search is being conducted under. This is important because the powers and obligations on the officers will depend on what act the search is being conducted under. Lawyers should be able to assist and advise on what powers and duties Revenue and Customs have and the officers have if they know what legislation or what section the search is being conducted under. If possible, ask the inspectors or the investigators to wait, ideally in a conference room away from staff, whilst a senior member of staff attends, such as a director. It's important that you ask, but don't insist, because officers may be willing to wait a short time, but they're not legally obliged to do so. And refusal to cooperate until a director or indeed external lawyers attend could be viewed as obstruction, for which an individual could be prosecuted separately for interference with an investigation or obstruction, irrespective of whether the raid leads to any further proceedings or charges. At this stage, I'll pause before I move on to the next section. Sarah, are there any questions just in relation to those first couple of slides?
I don't believe any have come in. Talia, please do let us know if any have. In the meantime, Michael, I was just wondering if it was worth you explaining what exactly a dorm raids policy should look like.
Yeah, well, that's a good question. I mean, the first point I would suggest is that any business looking to draft or implement a policy should take legal advice. But a checklist should include, or a policy, sorry, should include, things like a checklist and guidance for frontline staff, covering many of the points that we've just covered in the first couple of slides. Also include a contact list with names, addresses, phone numbers, email addresses of external solicitors, senior individuals within the firm who can be contacted in the event that no one is physically in the office when officers attend. That probably should extend to details of key members of staff that would be needed in the event of disruption. So head of IT, for example, head of human resources, head of HR, head of personnel, things like that. It's also important, the policy doesn't need to be particularly detailed as long as it sort of covers the main points. It's important that a policy is, everyone knows where it is, that it's easily accessible, and also that it's regularly reviewed and updated as staff members leave and are replaced. I would suggest that a policy should probably also include, and we'll come on to this later in the webinar, what a firm should be doing after the raid to mitigate any damage to reputation, but also business disruption as well, to make sure that the business is able to get back on track as soon as possible.
So it sounds like it needs to be sufficiently detailed and a point of reference, and within it there's a standalone one-page checklist type thing or double-sided checklist that can be used to equip the person should a raid occur. Yeah,
I think that's probably, obviously each company or business will have a different approach to it, but I don't see why, a simple one or two sides of A4 checklist. Have you done this? Remember to do this. Remember to do that. Remember to call this person. And then at the back with a glossary of people's contact details. Yes. I think that would cover most eventualities, I would have thought.
Yeah. Okay. Thanks for that, Michael. So if there are no further questions, shall we continue?
Yeah, sure.
On to action required by a senior member of staff.
Yeah, so thank you, Sarah. So reception have been approached, or the officers have come in, and reception have rang up to the director or the senior member of staff. So things are getting serious now. What action should be undertaken by that senior member of staff? Well, if possible, the first thing they should do is immediately call the in-house legal team, if there is one, and or external legal advisors, and advise them that a raid is taking place. Discuss the subject matter and purpose of the raid, if known, with lawyers beforehand, before going to meet the inspectors, to agree an action plan. Ascertain how long it's likely to be before lawyers can be present, if at all. After that meeting, the senior member of staff should go down to the front reception and make themselves known to the inspectors, ask, check any authorization documents, which hopefully would have been copied by the reception staff. They should state the subject matter of the investigation, albeit in broad terms, and the legal basis for the dawn raid. Again, in due course, this will enable the solicitor to identify which rules ought to have been applied to the inspection, and as we've said, the scope or limits on the inspector's power. Appoint a team, ideally, if possible, of shadowers. They will be able to, we'll come on to it, but ensure that the inspector's actions are recorded, any documents are recorded, and that any questions that are given, notes are taken. Shadowers should be briefed as to the limits on the inspector's power, what they are there for, so much as it is known, and as I say, to keep a record of which documents have been reviewed, copied, seized, and any questions that have been asked of staff, and we'll come on to that later on in the webinar, and any answers that may have been given. Next slide, please, Sarah. Yes, also important for a senior member of staff to ensure that all the other directors and senior management team are made aware of what's going on. Also, critical members such as the internal IT team, they will need to be contacted to ensure compliance with requests for inspectors to shut down the telephone system or the email system, and any issues that may arise when searching electronic documents or electronic servers. That senior member of staff should also send an email to all staff in the premises to explain what is happening, the need to cooperate, but ultimately to pass any questions or requests from the inspectors to him or to a response team leader if that is not them, and not to discuss the dawn raid with anyone outside of the business. That's a particularly important one, not only from a legal requirement to keep matters confidential and not to essentially tip off other members of staff or other businesses. That could be a separate offence in itself, but also to mitigate any reputational damage. It's amazing how many times I've represented individuals or companies subject to a raid where during the course of the raid they're being phoned up by their clients saying, oh, we believe you're believe HMRC are there. I don't know how it happens, but it does. So anything that can be done from the business side to ensure that that information is not leaked out into the public domain is very important. Okay, I think we've covered all that. Are there any questions at this stage before I move on to the next section?
I have a question here, Michael. What advice would you give to a business that has no staff physically on the premises at the time of a raid?
Yeah, I mean that's a really sort of pertinent question, Sarah, isn't it? I mean, it's obviously right to say that in the last few years, the way that we have done business, the way that businesses operate has dramatically altered. Many more people are working remotely, adopting hybrid working methods, and that means that there are fewer and fewer people physically in the office on any given day. I mean, we're yet to see really whether and how that has affected prosecuting authorities such as HM Revenue and Customs as to whether they will need to adapt their approach to raids in light of this. But the other aspect, as I've just touched on, is it's difficult for companies as well to control the flow of information when staff aren't physically in the office. So it's more important than ever to ensure that, you know, a company has a full and robust policy to ensure that everyone knows what to do, what not to do, and what not to say.
Yeah. And is it the case, Michael, that a raid of directors' residential addresses takes place at the same time, or is it really a case of it depends what's being investigated?
It does depend, but it is more common than not that officers will attend at both addresses. So they would tend to attend at a director's address slightly earlier. You know, we've called them dawn raids, but obviously if you execute a dawn raid on a business premises, it's unlikely that anyone's going to be there at dawn. So raids would tend to be sort of around between 9-10 o'clock in the morning at a business premises. But you're quite right, directors, it's usually around the breakfast table, sort of 7-8 o'clock. You know, their home addresses are searched at the same time. Usually two teams will go. One to the business premises, one to the director, if there's only one director, but obviously if there are more, there'll be more teams. And they will subsequently be sort of interviewed, more likely than not, but I'll say that will come on to that shortly.
Thank you. Okay, we'll move on, shall we?
Thank you. Slide 8, please.
Yeah.
Yeah, so we're just going to touch now on the physical handling of documents and material. First point there is it may seem a rather obvious comment, but it is important that you do not conceal or destroy any documents or indeed tamper with anything. It is an offence of perverting the course of justice, which will carry a separate prosecution, irrespective of whether there are any criminal findings as a result of the raid. And the starting point for perverting the course of justice or interfering with an investigation is custody. The courts take a very, very dim view of it, so that really is a no-no. Record everything that the officers do. We've touched on this earlier, but it's very important that this is done, that your shadowers, if you've been able to utilise them, record everything that the officers do, where they go, who they speak with, what documents or property they take and where from. The subject of the raid ought to receive a search log at the end of all items taken and where from. But from experience, it can be quite vague. For example, an entry will say paperwork taken from back office, which isn't particularly helpful if down the road, after a few weeks later, a particular file or document is needed for that business to complete a deal or finalise a tax return. The better defined the document is and its location, the easier it can be traced and returned. Always accompany the officers. Try not to leave them unattended. I'm sure that officers will try and put all staff into a room so that they don't interfere with the investigation, but it's important and you ought to insist that at least some staff are entitled to be present. It's likely that officers will ask questions of staff about the company, what their personal knowledge or understanding is of potential offences. So it's important that staff are made aware that any answers could be recorded either by officers wearing body-worn cameras these days, or old-fashioned entries in pocket notebooks. And ultimately that could be used in evidence or assist with a decision to prosecute a company or individuals. So it's important that staff are encouraged to refer any questions above and beyond the most sort of basic to the company senior management and ultimately legal advisors. Make sure that what is being seized is within the terms of the warrant and is not legally privileged, for example. Legal privilege will refer to documentation and material which refers or includes legal advice and litigation support, and that will cover communications between lawyers and clients, but not necessarily third parties. Provided the communication's primary purpose is that of seeking advice or receiving legal advice, it will be covered under legal privilege. And that can extend to commercial or indeed strategic advice. If identified as legally privileged, the material ought to be separated from the other material and not interrogated in the same way until reviewed by an independent person, usually independent counsel or barrister. Therefore, it's important, if the company considers ensuring that all legally privileged material is separately filed where possible and not mixed in with other non-privileged material to avoid cross-contamination. Although there may be, from a strategic point of view, it may assist to actually slow the search down if that material is mixed in, and it will take the authorities longer to separate it and ultimately send it away. So it may be one for business to consider whether it's in their interests or not to keep it all together. It's likely that devices and documents will be taken and held for considerable time whilst they're copied and analysed. Therefore, businesses may want to consider offering to make copies of all original hard copy documents that officers wish to seize. The benefits of this are twofold. One, it will prevent the officers from taking everything and not returning it for weeks. And secondly, if you have two copies, one copy for yourself and one copy for the officers, you immediately then have a list or a bundle of all the material that is subject of the raid, and that can be reviewed separately with legal representatives after the event to sort of strategize as to where an investigation may or may not be going and any issues that can be identified. Copies of everything seized will be returned, including digital devices, once copied, unless, the only caveat to this is unless that they are likely to be used as exhibits in a criminal prosecution if it gets to court proceedings. But this can take weeks for it to be copied and returned. So it's important, as we touched on, as Sarah touched on right at the start, that clients, firms back up regularly and have plans in place regarding business interruption to minimise any effects. So Sarah, is there any questions there before I move on to the end of the raid?
Michael, with this, as you suggested, move to a hybrid working model, it's inevitably from time to time will occur that perhaps you viewed something personally on your work computer or saved a document. Is there any risk of HMRC going through personal documents stored on work computers?
Yes, I mean the short answer is yes, there is a risk. You know, that material, as you've said, for example, contained on an internal server. The main issue, of course, will be personal emails on work computer. They will be held on a server, which will be seized. So it's important, really, that staff are careful about what personal information or what they do in a personal capacity on their work phone, on their work computer, at their work desk. Of course, GDPR and the Data Protection Act are now in force, which offers some security to a personal individual regarding personal material and personal data. But of course, it's important to note that Her Majesty's Revenue and Customs, or be it the local police force, in conducting a criminal investigation, that is one of the exemptions to GDPR. So the safeguards afforded by GDPR wouldn't apply to a criminal investigation in that regard. That being said, I mean, HMRC or the police, whoever it is who is conducting the raid, should only really be reviewing material which is relevant and pertinent to the subject matter of their investigation. As part of that, they should be applying search terms, relevant search terms, to streamline the documentation that they're reviewing, rather than interrogating each and every document, which for a business could run into hundreds of thousands, if not millions of documents. So personal material will in all likelihood be filtered out as part of that search. So in likelihood, it probably would not be too much of an issue, but the risk is always there.
Yes, and we're not suggesting that there is anything untoward, but no. I for sure know that HMRC can get carried away if they think they've got a particular lead into something, and it takes quite a lot of effort to persuade them that there's nothing in it for them.
Well, exactly. Then unfortunately, they're not going to take a person under suspicion's word for it, and likewise, they may not take a solicitor's word for it, that the material isn't relevant. So whilst, often now Revenue and Customs will seek assistance from individuals under suspicion and offer them an opportunity to provide search terms or things that are of relevance. Yes, you're quite right that they are the ultimate arbiters at the end of the day, and they will decide what they want to look at. So it is a risk.
Yeah. Okay. Thanks, Michael. So moving on.
Yeah. So thank you. We'll move on now to the end of the raid. The officers have been there probably all morning, making a mess of the offices and seizing documents and electronic devices. What will happen is a senior or a nominated individual at the firm will be handed a copy of the warrant if it's not been provided at the start, but also a search log. And the search log, as I touched on earlier, will identify what's been taken and where from. It's important to check the search log and ensure it's accurate before signing it or signing off on it. I don't think physically you need to sign it, but you will be asked whether you have any comment or whether you're satisfied with the log. So if there are any objections or any issues, it's important that it is recorded on that document or wherever possible, or a note is taken by the officers in a pocket notebook or on body-worn camera. Secondly, reserve the company's right to challenge the seizure of items and provide answers to questions at a later date. Those rights are enshrined in law in any event, but it's important that any complaints or issues are raised as soon as possible, and ideally with the officers present for the raid. It's not unusual for company directors and senior individuals to be conveyed, as we said earlier. They may have been visited separately if they're not present at the business address, but it's likely as part and parcel of the investigation they will be invited. I say invited in sort of guided terms. They'll be taken to the police station and interviewed under caution. So it's very important that any interview is conducted with legal representatives to ensure that legal rights are not eroded. if a solicitor, sorry, is not physically able to attend during the raid, it's still even more important, possibly, that they are someone from the solicitors attends any interview under caution with each and every person from the business that is interviewed. Thank you. The next slide, please. So the officers have left now. What should happen immediately thereafter? It's sensible and advisable to hold a debrief with lawyers after the raid to review, where possible, the documents or categories of documents that have been seized. It's also important to identify any documents which haven't been seized, which may be relevant to an investigation, because there's nothing stopping the authorities from raiding a premises again. It's very unlikely, but it could happen if material or it comes to their attention that they've missed things, or or the scope of their investigation has widened. They may not return physically, but there may be correspondence thereafter saying, we now want to see this documentation as well, so can you provide us with this? So it's important, if possible, to have those conversations and to be thinking about that if there's anything that glaringly or appears obvious that's been missed. If the documents seized portray an unfavourable or misleading view of the company, it's important in any debrief to consider how this impression could be corrected. Again, if there's material that falls outside the scope of the warrant, but from a firm's perspective may assist and may exonerate individuals or the company as a whole, then there's no reason at all why that can't be brought to the attention of Revenue and Customs and arrangements made for the copying and transfer or serving of that material. Consider reputational issues as well. As I said to you before, it's likely that this, as I say, I don't know how it happens, but it's likely that this information could be leaked to competitors, customers, or clients who may be ringing saying, what's going on? Are we still able to do business with you? And things like that. Consider how any reputational damage can be minimised or controlled in terms of a ring around to clients, something posted on social media, business as usual, that kind of thing. If a company or a business has a PR team or individuals, external advisors from PR, then it may be sensible to engage them at this stage in the debrief and see what advice they can offer. Okay, so I think that's pretty much everything. Thank you, Sarah.
Thank you.
That is my presentation. Thank you very much for your patience and your time. Sorry for the little bit of technical issues that you couldn't hear me for a part of it, but I hope you found it of interest. I know I've sort of whizzed through it. That probably is about 40-45 minutes, Sarah, so bang on schedule. I don't know if there are any questions that have arisen throughout that we've not addressed.
We'll check that now, Michael. I wonder if it's worth you giving some closing comments on how you envisage the HMRC raids of the future, because obviously HMRC have had to pause that type of activity during the pandemic. So you and I are doing this webinar because we envisage it to be a possible focus area going forwards. So it might be helpful to offer insights as to what may differ
yes,
in the future.
Yeah, of course, and I think some of them we've touched on. but you know, the last few years have seen many changes to traditional work practices, working from home, increasing working from home. COVID has affected the way revenue and customs and other organisations potentially are physically able to act once they come into a premises. You know, in terms of additional measures that need, safety measures that need to be put in place with regards to physically interacting with people. The decrease in the use of hard copy documents. I've, you know, for example, Weightmans, I'm sure many other businesses have a paperless office. So the relevance of hard copy documents is perhaps becoming less and less. And that has its own problems. If everything is stored digitally on a server or a cloud server even, that cloud server may not even be physically in a premises or in an office or indeed in this country. So that will have implications for how revenue and customs are able to seize or lock down on that material. And it will make it increasingly more challenging for them to secure that material. They'll need to consider executing warrants on cloud server hosting companies at the same time, or even instead of the business that they suspect of committing the offences. As I've said, many of these servers may be held in offshore jurisdictions that will require, letters of request being sent to foreign governments or foreign prosecuting authorities for them to conduct the searches. So an increase in international cooperation, which of course with the advent of Brexit is probably going to involve a lot more red tape than it used to. We touched on GDPR and the Data Protection Act, and of course I've said that criminal investigations are exempt, but of course in broader terms, HMRC need to be a lot more careful and a lot more targeted with the material that they ask for, request, and ultimately seize. The days of just sort of fishing expeditions, we used to call them, or revenue and customs having carte blanche to go through everything, is over. So whilst GDPR technically an exemption will apply, the rules and regulations around how HMRC as a organisation and as a public authority obtain, handle, process and deal with data is still a relevant consideration. We again obviously touched on hybrid working from home. There may be an instance where revenue and customs turn up in an office and there's nobody there. How's that going to work? How physically are they going to be able to sort of put the genie back in the bottle, so to speak, when everyone knows, or word has got out to a company's directors that a raid has been executed on their premises when there's nothing of value there? So yes, I mean there are a number of questions and a number of issues. I suspect revenue and customs is probably working through them, or deciding how, if at all, it deals with these. But it will be interesting moving forward the next few years, as obviously COVID and the physical blocks recede away, how revenue and customs decide to approach these situations under this new sort of regime and business regime. Yeah.
Thank you, Michael, and you've dispelled any doubts as to the importance of this topic. Whilst I tried to ensure I mentioned that it's unlikely that a business will be raided. Hopefully all that listen to the webinar will agree it is worth implementing the steps that we've discussed now to best protect against that unlikely eventuality. So thank you, Michael, for presenting for us today.
Thank you.
If anybody else has any more questions, please do use our contact details to send those through to us, and we will respond personally. The recording to this webinar will be shared, so another useful tool for distribution to your teams to increase knowledge about how to handle a raid. And I think all it leaves me to mention now is news of our next webinar, Tuesday the 4th of October, and that will be on capital allowances and presented by my colleague Russell Bennett, who is a great guy and a very funny guy, so I'm hoping he will be able to provide some humour in, no doubt, what will be a great presentation. So please do join us there, and I'll now leave you all to get on with your afternoons. Thank you very much.